FEMA, emergency, natural rights, they still rule. There are many individuals that are worried about the potential fact that our countries, Canada and America, can be drawn into an emergency situation, and that during this situation, all of our rights and freedoms will be taken away from us. You can find videos here on YouTube stating that during an economic or other crisis, FEMA will come in and take men and women against their will to the FEMA camps. That the military will patrol the streets and will come into our homes under the direction of FEMA, and so forth. There are many stories out there of what will potentially happen. The common scenario is someone is telling you that you should be afraid because they will take away all your rights and freedoms when martial law is declared. When you look into the United States of America, 6 U.S. Code, Section 313, this deals with Federal Emergency Management Agency, better known as the FEMA. Now, when you look in Section A, in general, it talks about there is in the department the Federal Emergency Management Agency headed by an administrator. So this department, this FEMA, is headed by a designation that is called the administrator. Now, mission, the primary mission of FEMA. The primary mission of the agency is to reduce the loss of life and property and to protect the nation from all hazards, including natural disasters, acts of terrorism, and other man-made disasters, by leading and supporting the nation in a risk-based comprehensive emergency management system of preparedness, protection, response, recovery, and mitigation. So FEMA's responsibility is to produce an emergency management system. That's their obligation. Now, specific activities. In support of the primary mission of the agency, the administrator shall lead the nation's efforts to prepare for, protect against, respond to, recover from, and mitigate against the risk of natural disasters, acts of terrorism, and other man-made disasters, including catastrophic incidents. B. Partner with the state, local, and tribal governments and emergency response providers, with other federal agencies, with the private sector, and with non-governmental organizations to build a national system of emergency management that can effectively and efficiently utilize the full measure of the nation's resources to respond to natural disasters, acts of terrorism, and other man-made disasters, including catastrophic incidents. So again, we're seeing the primary reason for FEMA is to prepare to build a national system of emergency management so that during a time of emergency such as terrorism, natural disasters, or other man-made disasters, there will be a management system in place to help the nation. So again, we have FEMA that's in operation, and the one who is leading or in control of FEMA is designated the administrator, and the administrator's job or duties is to prepare an emergency management system that can be in place and in operation during a time of emergency. Now, when we look to Canada's Emergency Act, we find the following. A national emergency. For the purpose of this act, a national emergency is an urgent and critical situation of a temporary nature that seriously endangers the lives, health, or safety of Canadians and is of such proportions or nature as to exceed the capacity or authority of a province to deal with it, or seriously threatens the ability of the Government of Canada to preserve the sovereignty, security, and territorial integrity of Canada, and that cannot be effectively dealt with under any other law of Canada. There are government enactments and regulations that have been created to deal with the nation during a time of emergency. The very description of the term regulation is to control and restrict. So they're creating regulations here, and we know that regulations are used to control and restrict, because the very definition of the word regulation is the act or process of controlling by rule or restriction. Both Canada and the United States of America have emergency plans in operation in case of natural disasters, acts of terrorism, or other man-made disasters. So when you look at it, if there's an emergency in the United States of America, it's FEMA that will kick in. And the one who's leading FEMA is titled or designated the administrator. If there's an emergency in Canada, it's the Emergencies Act that kicks in, and it's the Governor General who's in charge, who has the duties and the responsibilities. Now, when you look to again in America, 6 U.S. Code, Section 313, it says the administrator. In general, the administrator shall be appointed by the President, by and with the advice and consent of the Senate. So the one who's leading FEMA is appointed by the President. They're not voted into a position. And on top of that, the administrator is the principal advisor to the President, the Homeland Security Council, and the Secretary for all matters relating to emergency management in the United States. So this administrator for FEMA is the advisor to all of these. The administrator is appointed by the President, and he is the principal advisor to the President, and also to Homeland Security, the Council, and the Secretary. Now here, the U.S. Code, again, Section 314, Authority and Responsibility. In general, the administrator shall provide federal leadership necessary to prepare for, protect against, respond to, recover from, or mitigate against a natural disaster, act of terrorism, or other man-made disaster. So the administrator is the one who's in charge. He's the big chief. He's the one who has the powers and the duties under the enactment. So during an emergency in the United States of America, the administrator will already have plans provided for that will meet for the protection or respond to or recover from a natural disaster, an act of terrorism, or other man-made disaster. And when these emergencies come to pass, he will implement these plans. In Canada, when you look at the Emergencies Act, it states the following: whereas the safety and security of the individual, the protection of the values of the body politic, and the preservation of the sovereignty, security, and territorial integrity of the state are fundamental obligations of the government. And whereas the fulfillment of those obligations in Canada may be seriously threatened by a national emergency, and in order to ensure safety and security during such an emergency, the Governor and Council should be authorized, subject to the supervision of Parliament, to take special temporary measures that may not be appropriate in normal times. So both of these countries have one officer in charge of the responsibilities, in charge of overseeing the regulations. In America, the designation is the administrator. In Canada, it is the Governor General. In America, we see the duties and responsibilities that the administrator is charged with according to the enactment. So the administrator is charged with helping to ensure the effectiveness of emergency response providers to terrorist attacks, major disasters, and other emergencies, providing the federal government's response to terrorist attacks and major disasters, managing such response, preparing and implementing the plans and programs of the federal government for a continuity of operations, continuity of government, and continuity of plans. When you look at the Canadian Emergencies Act, you find the following: declaration of a public welfare emergency, orders and regulations. While a declaration of public welfare emergency is in effect, the Governor and Council may make such orders or regulations with respect to the following matters as the Governor and Council believes, on reasonable grounds, are necessary for dealing with the emergency. So when we looked into the American description of what your administrator can do, they didn't really pinpoint. They say generally the duties and responsibilities that he has, but they don't really describe it down to a T. But when you look into the Canadian Emergencies Act, you're going to see exactly the powers that they're taking. So while in a declaration of emergency, they have the power to the regulation or prohibition of travel to or from or within any specified area where necessary for the protection of the health or safety of individuals. So if they declare that it's necessary for your protection, for your health or safety, they're going to limit or disallow you to travel in certain areas. The evacuation of persons and the removal of personal property from any specified area and the making of arrangements for the adequate care and protection of the persons and property. So again, if they decide that they want to remove persons and personal property from your house, from your area, then according to the Emergencies Act, they will have the right to do that. Now, if they want to, the requisition, use, or disposition of property, if they want to take over your property, if they want to use it for any reason, according to the Emergencies Act, they will be allowed to do that. They can requisition your property. The regulation of the distribution and ability of essential goods, services, and resources. So they're going to control the movements of goods, foods, and services, and the establishment of emergency shelters and hospitals, such as Fema camps and the like. So when we read it in the Canadian enactment, we see exactly what they're planning on doing. We see exactly the rights that they're planning on stripping us and the things that they're planning on doing to us, such as evacuating us from our property, removal of our personal property, maybe taking over our property. So if the order comes down under these regulations and enactments, such as evacuate your property, evacuate your personal property, we need to use your property for such and such purpose, or we want to evacuate you to an emergency shelter, to a FEMA camp. And if you fail to abide by what they're asking you to do, then they made a provision in the enactments and regulations themselves to fine you or throw you in jail. So on summary conviction, you can be fined $500 or imprisoned not exceeding 6 months, or you can receive both the fine and the imprisonment. If you're indicted for not following their orders, you can be fined not exceeding $5,000 and imprisoned not exceeding 5 years, or you can receive both the fine and imprisonment. Why? For contravention of any order or regulation made under this section. So we order you to perform a duty under this enactment, and you fail to perform the duty that we're requiring you to do, we're going to fine you according to this enactment. This is what you would call their servitude clause or their servitude power. Basically, it's do as I say, do as I command you through this enactment, serve the enactment, serve us through the enactment, or we will fine you for disobeying. We will punish you, imprison you for disobeying. That is servitude. That is against our inalienable rights. Now, when you look to 6 U.S. Code, Section 321, that should be guidance and recommendations. So, in general, consistent with their responsibilities and authorities under law, as of the day before August 3rd, 2007, the administrator of this enactment and the Assistant Secretary for the Infrastructure Protection, in consultation with the private sector, may develop guidance or recommendations and identify best practices to assist or foster action by the private sector in developing and maintaining emergency preparedness and response plans and associated operational procedures. So here they're saying that the administrator, when he's developing and maintaining these emergency preparedness and response plans and associated operational procedures, he can have the help of the private sector in doing so, in making these plans. And that's what we see transpiring when we do our research. Now, when they're talking about evacuating persons and the removal of personal property from any specified area, well then the administrator can use the private sector to do this. When they talk about establishing shelters, those FEMA shelters, Well, again, they can use the private sector to do this. Now, they're talking about giving imposition of summary convictions or a fine or imprisonment for not obeying what they're asking us to do. So both the United States of America and Canada have created government enactments and regulations that will be used as controlling and restricting instruments against men and women during a time of emergency. If they want to come into your home, they will claim they are justified, they are allowed to, because the regulations allow them to do so. If they want to take your personal property away from you, your guns, your food, whatever it may be, they will claim they can do so because the regulation allows them to. The administrator implemented a plan for these actions. You see, here in the regulation, the administrator, the governor general, said, we have the power to do it. If they want to remove you from your home and bring you to a shelter, a Fema camp, then they will claim that they have the legal right to do so because the enactment, the regulations, are giving them color of right, are giving them color of law to do these actions to you. The officers on the street are only following the administrators and the governor's order through the enactment. So I guess these men and women who are saying that we have no way to fight back if martial law is declared, that we simply lose all our rights and freedoms, they were correct. Have a good day, everybody. No, this is not true. Our rights and freedoms are not being stripped away. There is a mechanism that is preserving them if you understand what's transpiring. Now let's start with Canada and we'll work into America. The Governor General in Canada, when he is taking these special measures in a time of emergency, has some restrictions against him, has some obligations that he must follow. When we look into the Emergencies Act of Canada, it reads as follows. Whereas the safety and security of the individual, the protection of the values of the body politic, and the preservation of the sovereignty, security, and territorial integrity of the state are fundamental obligations of government. And whereas the fulfillment of those obligations in Canada may be seriously threatened by a national emergency, and in order to ensure the safety and security during such an emergency, the Governor and Council should be authorized, subject to the supervision of Parliament, to take special temporary measures that may not be appropriate in normal times. And whereas the Governor and Council, and here it comes, in taking such special temporary measures would be subject to the Canadian Charter of Rights and Freedoms and the Canadian Bill of Rights, and must have regard to the International Covenant on Civil and Political Rights, particularly with respect to those fundamental rights that are not to be limited or abridged, even in a national emergency. So within the International Covenant on Civil and Political Rights, there are rights and freedoms that are enumerated, that are listed in the covenant, that are not to be limited or abridged, which means removed or restricted, even in a national emergency. And this operation of law is existing in Canada, and it exists in the United States of America also. Well, here we are learning that we as individual men and women, we have fundamental rights and freedoms that can never be limited or abridged, even during a time of emergency. When we look at the 6th U.S. Code, Section 321 again, under Guidance and Recommendations, look what it says under subsection D. Rule of construction, talking about this whole enactment, talking about the whole FEMA enactment. It says nothing in this section may be construed to supersede any requirement established under any other provision of law. So if there's any other provision of law operating in America that produces rights and freedoms, that supersedes or goes against what is being declared in this enactment, then you have the right to call upon those rights and freedoms. This is expressing the exact same thing that we just read here in the Canadian enactment, but it's doing so deceptively. Here it says specifically that the Governor in General has to have regard to the International Covenant on Civil and Political Rights, particularly with respect to the fundamental rights and freedoms that are never to be limited or abridged, even in a national emergency. In America, it just states that Nothing in this section where they talk about the administrator's plans concerning developing and maintaining emergency preparedness and response plans and associated operational procedures. Nothing in this section. It can be construed or taken to supersede, which means to overimpose itself or to rise above any requirement established under any other provision in law. So if you have a fundamental right and freedom flowing through your constitutional act, flowing through the international covenant, this enactment, the Fema enactment, has no authority to remove your right, has no authority to limit your right. And that agrees with what's transpiring in the international covenant and with Canadian law. So when you look again at what the administrator has power over in America, it says he can develop and maintain emergency preparedness and response plans and associated operational procedures. So he can make plans for the evacuation of persons and the removal of personal property from any specified area. And the administrator can make plans to create emergency shelters, those FEMA camps. And your administrator can make plans to fine you or put you in prison for not listening to what he's telling you to do. But the administrator is under the same obligation, and he must have regard to the International Covenant on Civil and Political Rights, particularly with respect to those fundamental rights that are not to be limited or abridged, even in a national emergency. Now, when we look into the International Covenant, we see the article of law coming out. It says, in the time of public emergency, what we've been talking about, when there's public emergency in America or public emergency in Canada, which threatens the life of the nation and the existence of which is officially proclaimed, the state parties to the present covenant may take measures derogating from their obligations under the present covenant to the extent strictly required by the situation, provided that the measures are not inconsistent with their other obligations. And then it states that no measures, no derogation from Articles 6, 7, 8, 11, 15, 16, and 18 may be made under this provision. So even in a time of public emergency, you cannot limit, you cannot abridge, you cannot remove the rights that are being brought forth under Section 6, 7, 8, 10, 15, 16, and 18 of the covenant. And we see this exact expression of law coming out very clearly here in Canada's Emergencies Act, where it says you cannot limit and abridge the rights that are in the International Covenant, and in America. So what are these rights and freedoms that can never be abridged, even in a time of emergency? So in a time of emergency, no one shall be held in servitude. And in a time of emergency, everyone shall have the right to recognition everywhere as a person before the law. The two main important, natural, fundamental, common law, inalienable, absolute rights that men and women can possess are still present and available for us to exercise, even during a time of emergency. Before, remember, I shared with you through the enactments, they say the administrator or governor general will make you do such and such actions, and if you don't follow their actions, then they're going to fine you or possibly put you in jail. And that's their mechanism to force you into servitude. Well, here, the covenant is saying you can't be held in servitude, even during a time of emergency. The administrator, the governor, would want you to obey their orders and submit to their decrees. If they declare that you should abandon your home and property, they want you to submit and serve their legal request. However, your inalienable right to decide what you will do is preserved for you. Even in a time of emergency, you cannot be forced into servitude to their enactments. These enactments concerning emergency planning are corporate in nature, and they only apply to officers of the corporation. Your right to decide if you will take recognition as this class of person in law is preserved for you even in a time of emergency. There is another reason why it is important to notify the executive party, the Attorney General, of your standing with your claim of recognition. Because if all this goes down, they're already going to know that you understand who you are, and they're already going to understand it's useless to try and force them to submit to what we're trying to do. They understand their rights, they know that we are obligated, and if we force them or try to abridge or limit their right, we open ourselves up to a future monetary lawsuit. America signed the covenant and ratified it in 1992 with reservations. So these fundamental rights and freedoms, which pre-exist all, are in operation in America. And it's through the Supremacy Clause, Article 6, subsection 2, that these rights and freedoms come into America. The obligations come out of the covenant itself. And you can go to my other video. I don't think I'm going to walk you through this, because I just finished explaining this in my last video. But here now you're seeing that now that you understand America has the obligation concerning your fundamental rights and freedoms, even if emergency comes upon the land, your fundamental rights, your natural rights are preserved, the most important ones, that allows you to stand up against the powers that would try and regulate you, against the powers that you are fearful of, that are going to come and harm you.